Today's distinguished lecturers are Skip Jennings and Jim McCallar. Skip Jennings Law Office is the law office of Skip Jennings, and Jim McCallar is McCallar Law Firm. And I have had the pleasure of working with both of these wonderful attorneys, and I can truly give them the highest recommendations. Today we are talking about bankruptcy, the B word, because I'm getting calls from friends, clients, former clients, asking questions about what they need to know about bankruptcy. So we're going to hear from the experts. We've gotten some questions in advance, and we'll also take questions live if anybody has any. And before we start, I just want to clarify that nothing we say here is legal advice. We're talking very broadly about a lot of things. So if you have a specific legal situation and need specific legal advice, please don't put those details in the comment section, but reach out to us individually. We'll give you our contact information. Because we just can't know all the details of your assets and liabilities and personal situations. So this is just general advice. Okay, now that we've gotten all the legal disclaimers out of the way, I think we're ready. My name is Rachel Wilson, and my firm is Nest Estate Planning, and I specialize in wills, estates, and trusts. I'm a native Savanian, and I also teach wills, estates, and trusts at 2 local universities. And this webinar is my small way of trying to help small businesses while we're all staying at home. So I hope you get some useful information out of this webinar series. Skip, would you introduce yourself and tell us what you do?
Sure. My name is Skip Jennings. I've been practicing law here in Savannah for 34 years now. I'm also involved in a lot of other stuff. People may know me from my involvement with music, whether it's the jazz festival or radio or other things. But, you know, the main thing for a job is being a lawyer here in town. Like I said, as I've been for 34 years. I'm a solo practitioner downtown at 115 West Oglethorpe. What I do is file bankruptcy cases, you know, primarily for people, but also I do some business bankruptcies. Jim does a lot more business bankruptcy than I do. And, you know, consumer bankruptcies, personal bankruptcies, that usually means Chapter 7 or Chapter 13, although it can sometimes mean Chapter 11 also. But we'll get into all of that, I'm sure, as we go along here.
Okay, thanks, Skip. How about you, Jim? Can you introduce us and tell us what you do?
Well, I could just say ditto, and everything would be cool. But I'll say Skip and I have the I guess benefit of working in the same building, so we get to exchange information every now and then, and that works out real well. And he sort of channels himself in a certain area of the bankruptcy world, and I channel myself in another, and sometimes they cross. So I do mainly Chapter 7s and 11s, which are individual bankruptcies and corporate bankruptcies. And I won't go into it in too much more detail there until we see what everybody's interested in talking about. But I've just been hanging around doing that for 50 years. And it's...
Is this your 50th year of practice?
Yeah, it's hard to believe. Only being 23, I did it for 50 years, but whatever. So we'll see if we can get some answers for everybody. This should be very enjoyable.
Well, good. So I guess the first thing we should do is talk about, I mean, most of these businesses and individuals never thought that they would be in a situation to file bankruptcy. So what do they need to know about it? What kind of bankruptcy should they file? What are these chapters, and what are the differences between them?
Well, the bankruptcy code is Title 11 of the U.S. Code. I mean, if you printed it all out, it would take up a huge wall. But Title 11 of the code is the bankruptcy section. And within that, there are different chapters of the code. Some chapters just have to do with administrative things and trustees and stuff like that. And other chapters have to do with specific types of bankruptcies. And that's, you know, people generally have heard of Chapter 7 or Chapter 13, maybe Chapter 11. There's other bankruptcy cases that can be filed under Chapter 9 or Chapter 12 or Chapter 15, but those are pretty rare. You know, for most folks, you know, if an individual is looking at a bankruptcy, you know, they're probably looking at a 7 or a 13. You know, I've had people come in and say, oh, I need to file a bankruptcy for my business. And my response to that is usually, no, you probably need to file a bankruptcy for yourself, because even if your business is going under, and there's no hope of reorganizing it, the problem going forward is going to be the fact that you, the business owner, are probably covered over in guarantee debt. from various bank loans and agreements you've signed with other vendors. I mean, you fill out a credit app for a vendor, and they say sign here, 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 and here. Well, one of those sign heres is a personal guarantee usually. So I mean, you may have a problem that you feel like your business needs to go under and file bankruptcy, but really the problem is more, how do you survive with the debt from the bankruptcy? And that usually means filing a personal bankruptcy for you.
So what do you have to say on that, Jim?
Well, probably everybody in the United States has heard the word bankruptcy before, and not that many people, if you take the population as a whole, have really participated in those things that the bankruptcy court deals with. But basically, as Skip said, there are programs for individuals who are not on the real, they're not on the airline financial end of the stick. Okay, they owe money. They owe money personally. They need to figure out how to pay that back over a period of time, and that's where you come into one of the chapters. And this bankruptcy code right here, you see how thick that is? That's about it. If you carried this book around, you would have the entire bankruptcy law. Now, with the cases and everything, and the treatises and everything that come out about it, yeah, you could fill up a building. But this is the bankruptcy code, and you see a bankruptcy lawyer. You don't, in my opinion, try to figure it out for yourself. Chapter 13 would help you as an individual. If you just are at your wit's end, you don't have any money coming in, you owe a lot more than you can ever pay back in a reasonable period of time, the mechanism flips over to another one called a Chapter 7, where you say, whatever I can keep, Judge, I'll keep. Everything else, it can go back, and I just want to be discharged of all these debts, and I want to start my life over again, my economic life. So that step is taken, and then without taking too much of the time here, I'll just say, then you go another notch up, and you get to a Chapter 11, which you hear a lot about. But anybody from a mom and pop grocery store to a multi-billion-dollar business can get themselves handled by the bankruptcy court by protecting them from creditors while they go through the phase of trying to either liquidate or stay in business, keep everything, and come up with a plan that the creditors can live with.
Okay, so Chapter 13. Oh, sorry, go ahead.
Yeah, so anyway, so you'll have lots of choices with, but you need to talk to somebody who's in the field, because it is a wide open. 50 states in the United States of America deal with the same bankruptcy code. And while we're dealing with the same bankruptcy code, we may have to look into a certain law in any one of the 50 states because of where the individual who's seeking our advice comes from, and where they last lived most recently, and where their businesses were, and et cetera.
So Chapter 13 is for individuals,
right?
Yeah.
That
want to restructure the debt. Is that correct?
Well, you're trying to pay as much as you can possibly pay with your payment, with your money that comes in minus your necessary living expenses. That's how the court and the code will look at it. And you're gonna try to pay that over a period of up to 5 years. And you gotta limit it to 5 years, and you may pay 10% of the debt, or you may pay 100% of the debt. It depends on what your available income is that the court's going to require that you apply to the plan.
And it really depends on what you're trying to do here. I mean, what is it you're trying to stop, or what is it you're trying to save here? If someone is trying to foreclose on your house, well, then you want to try and file a Chapter 13 usually, because Chapter 13 provides a mechanism for you to bring your mortgage payments current again over the probably 5 years of your plan. The same thing as if someone's trying to repo your car, or if someone has just repoed your car, you're going to want to file a Chapter 13 to try and get that car back. If someone's garnishing your bank account as a judgment against you, well, you might file Chapter 7 then, because Chapter 7 is best for dealing with your unsecured debts, which are things like your credit cards, your medical bills, signature loans, business guarantee debt, things like that. In Chapter 7, basically what you're doing is flushing all those things. In Chapter 13, though, what you're trying to do is, you do want to try and get rid of your unsecured debt if you can in Chapter 13. But usually in a Chapter 13, you're trying to do something else. Again, like save your house or your car, or maybe you're behind on your alimony and child support and they're about to throw you in jail for contempt. You want to file Chapter 13 then too. So again, you have this mechanism to pay what you have to pay back over time. And as long as you make your payments faithfully to the Chapter 13 trustee's office, you'll be okay on all of that.
Now, what about 11? Is 11, you said 11 can be a small mom and pop store or Neiman Marcus, right?
Right. That's a situation where a company, well, first of all, the company has to decide what it needs to do and what it can do. It's basically in some kind of trouble if it's talking to a lawyer about a bankruptcy of some proportion. And a Chapter 11 could be one where they say, we can't continue, but we got value in our property, and we know that value will go a long way toward paying our creditors. So what we want to do is we want to file a Chapter 11 and put our assets up for liquidation and pay as much as we can to creditors, then close the business down. And then, of course, the opposite is where you want to stay in business. A Chapter 13 person wants to continue to live after their 13 is over with. A Chapter 11 debtor who wants to work out a deal with their creditors in a formal way, that would be a Chapter 11. And there are all sorts of issues that come up in deciding what to file and in implementing what to file.
So the people watching today don't have to decide.
Corporate guys we talk to.
Right.
It could be an individual as well.
Going to talk to a bankruptcy lawyer.
Farmers have their own ability to pick up and say, I think I would like to file something like a Chapter 13. Should I do that? Well, the decision there is, well, is it going to be a Chapter 13 like Skip talked about? Is it going to be a Chapter 11, or is it going to be what we call a Chapter 12, which is limited to farmers, the family farmer? Okay, so they have different possibilities because they have different issues. So they're seasonal. Their crops are generally seasonal, and they have all sorts of issues that come up that maybe wouldn't come up in a Chapter 13. Let's say if you were a farmer, maybe you want to file a 13 because you don't know that much money. Maybe you want to file 11 because you don't want to file a farmer's case. So we have lots of options, but until we really go over things with the client, we don't know where it's going to lead. We have a rough idea, but it's rough.
Definitely.
And I'll back that up too, because I know it happens all the time. People come in and they say, I want to do this or I want to do that. And say, well, no, let's talk about your situation first. Let's get all the facts out on the table here. And then we can decide what chapter might help you in your situation. I mean, when people come in, and usually we talk about bankruptcy in general, we get, the basics of their situation so we can see which chapter of bankruptcy relief potentially offers them the most relief they can get.
And let me add to that. The schedules are very similar in each one of those chapters, but they have one goal in mind. The court wants to know from the debtor everything it owns or you own, and everybody you owe, and how much money you're making. And those elements are going to come out, and those elements are going to set the calendar on the case, and it will tell us in the court where we're going to be able to most successfully go.
Gotcha. So, Skip, you mentioned that when a person comes in and says, I need to file a bankruptcy for my business, that it really might be a personal bankruptcy, but can you file both? Can you file personal and business together?
I laugh because I know Jim's had some situations where he tried to represent an individual and a business in separate bankruptcy cases, and that led to some other stuff. But anyway,
it is. What's funny is you can do that if there is no conflict between the individual and his company.
Yeah.
or you can have the individual with a company and another company. And sometimes it's easier to merge the two and handle them together, or to let the two cases run one sideways. I can say I've probably seen most everything that can happen in a chapter 11 or a chapter 7 or a chapter 13. And sometimes, they come about because somebody's just not being truthful with the schedules. They 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 don't get the big picture, even though you try to explain it to them. But when you say all of your assets, to them it might mean, oh, my assets. Oh, well, that's not the house I have in Wyoming. No, that's an asset. It's in Savannah too. You know what I mean? It's wherever those assets are. They could be in the Caribbean, but the bankruptcy court finds out about it and you didn't list it. What the easiest thing that's going to happen is you're not going to be able to proceed with your bankruptcy. So then you'll have all those creditors climbing down, filing suits at the same time, which is another reason bankruptcy court helps people. Is you're not going to be dealing with 75 lawsuits. I mean, you got 75 creditors. 75 creditors could file you in state court. Some could file them in superior court, and you'd be chasing them around and paying a fortune out to get defense. This is bringing everything back into one place, the bankruptcy court, where it is. Where you are best able to get success.
Well, the question that I have received most from the people watching this and the people who submitted questions in advance is, how do you know when it's time to file? If a business isn't out of money yet, but they know that they will be in 3 weeks or 3 months, when do they call a bankruptcy attorney? After the bills are 6 months past due, or when they know that their bills are going to be past due?
When do you take your dog in surgery? After you completely run out of money? I don't think that worked out real well.
I look at it, when is something bad about to happen? That's when you have to file. Now, yes, you can say you should come in before that and understand what your options are with bankruptcy. But in terms of when you need to file when something bad is about to happen, like someone's going to foreclose on your house, repossess your car, garnish your checking account, garnish your wages, or seize some assets of yours somehow. When those bad things are about to happen to you, that's when you have to file. But you should, if you see the writing on the wall, if it's probably not making it, then you should, make an appointment with someone like Jim or me or one of the other fine bankruptcy lawyers here in town, and talk to them and find out, what your options are given your situation.
Yeah, a good example of that, as Skip well knows, and that is, don't wait until Monday afternoon to stop a foreclosure you've been dealing with the creditor for months and months and months. The creditor advertised it for a month. It's going to close the first Tuesday in the next month, which is tomorrow, and you want to go see a lawyer about it. Yes, there are ways to stop it, okay, but it sure does put a lot of pressure on the lawyer to put everything together and know that this is going to be a good case when you walk in the day before foreclosure day. You have a sense far more than the day of foreclosure, for longer, to be able to talk to the lawyer about it and say, this is what I know, this is what mess I'm into. What should I do?
Not only do you put a lot of pressure on the lawyer sometimes will come around and say, I need a much bigger retainer because you're coming into me at the last second here and are making this more difficult. So I've got to drop everything else to take your case right now because you've got a foreclosure scheduled for 10 a.m. tomorrow morning. I mean, if you get a notice saying there's certified mail for you at the post office, go get it. Don't
Yes.
oh, I'm not going to go get this, then something bad might happen. No. What's going to happen is going to happen. You need to know what's going on. So if you get a notice that there's certified mail for you at the post office, get your butt down there and get it, because that may be a notice about the foreclosure, and it's happening whether you get that letter or not.
I call that the ostrich. If you just put your head in the sand and pretend like it's not going to happen,
yeah.
if you don't pick up the certified mail.
Yeah.
It doesn't help. Okay, so what are the repercussions for filing bankruptcy? I know that it affects your credit, but tell us a little bit about that.
I don't think it really affects you that much these days. I mean, there was a time, of course, when there was a stigma to filing bankruptcy. That stigma has long since disappeared. Of course, 10 years ago, when we had the big crash, then I was regularly filing bankruptcy cases for people who had been considered millionaires 2 years before that. But then when the real estate crash happened, and their assets weren't worth what we thought they were worth, suddenly these folks, and they couldn't refinance their adjustable rate mortgages and things like this. We had a lot of people filing bankruptcy then. There's no stigma to it anymore. Yes, you'll take a hit on your credit score, but I always urge people not to get wrapped up in what their credit score is. Yes, you need credit to buy a house. Yes, you need credit to buy a car. But beyond that, you really should avoid using credit. You should buy stuff when you have the money to pay for it. And not get into this thing about, well, I can afford the payments on this, so I can afford this. No. Reject that idea. You should again, just use credit for limited purposes, and that way you don't get in the situations that we see every day.
You'll also find in many cases that a creditor, when it's bad enough, a creditor will tell you, go see a bankruptcy lawyer. I mean, really, in many cases, it's easier for them if their customer or their client would go see a bankruptcy lawyer, because then they feel like they're not going to get in trouble because something's going to happen. Somebody's going to be in touch with them, tell them what's going on, and then it's going to probably end up in bankruptcy court. But many times, when you only have one or two creditors, things can be worked out. They're realistic. If they're owed $100,000 and they know that you only have $15,000 worth of assets and no possibility of going to work, why do they want to chase you down for the next 3 years? They just want to get it over with the best conclusion that can be found. And I guess when you can move assets to convert it to money, people feel more comfortable being in bankruptcy court, even in a straight bankruptcy of Chapter 7, where they have a trustee who is going to have the job of finding out which of your assets you have equity in, so that they could sell them, pay the creditor, and then use the rest of the money in the case for other creditors. So in many cases, that's what ultimately gets you free of all the debt, and you get another chance. If you're going to be chased by creditors for the next 10 years, you're not going to have a chance to do anything. You're not going to borrow money. You're not going to open up a business. You're not going to do anything, because you don't know what day one of those creditors is going to send a notice, and they're going to come in there and shut your new business down because you didn't file a bankruptcy. Now you have more assets. So that is not a good position to put yourself in. You've got to deal with the assets and get rid of them, either by working with the creditor, working with a court, or the bankruptcy court.
And I would say this too: file bankruptcy when you're down. Don't while you're unemployed. File the bankruptcy then, because if you go out and you get that good job you think you may be entitled to get, or you may think you're qualified for, you get that good job, suddenly you may not be eligible for Chapter 7 bankruptcy anymore, where you just flush everything. So file the bankruptcy while you're down, while you're unemployed, so that you're in the best position to qualify for the bankruptcy that gives you the best treatment and gives you the kind of relief that you need.
And let me say this too: when at all possible, individually or your business, pay your taxes. You're not going to get rid of them. You're not going to get rid of them. You're not going to not pay your withholding taxes, not pay the income taxes on your business, and 2 or 3 years later say, "Oh boy, I'm gonna file a bankruptcy. I got to get rid of this." Well, you do that, and if the rest of the world falls apart, IRS is going to be there to try to figure out where their property is going to come from to apply to your debt. And I mean, so many people wait and they wait and they wait, and they have a huge amount, because the government doesn't have time to chase everybody down and to be right on top of everybody's returns, or seeing where, well, this one used to file withholdings all the time and now it doesn't do it anymore. Well, are they closed, or are they just not filing it anymore? So that thing can go on for several years. years. And all of a sudden, now you are hit because you are going to be responsible for paying those withholding taxes, plus interest, plus penalties, which have amazing growth.
I would say this: if you think your business is going under and you have a number of different debts that that the business has, throw every dollar you have at paying your taxes. If you're behind on like your 941s, your FICA taxes and things like that, if you're behind on that stuff, throw don't pay anybody else. Pay those 941s, because the IRS will chase you for the rest of your life for those taxes and then file a claim against your estate once you're dead. So, I mean, that's the one thing you cannot do anything about. Don't pay your bank loan, don't pay your vendors, pay the taxes if you already know you're going under, because that's the debt that you can't do anything with other than pay it.
And let me tell you something. I don't know why people shouldn't be so scared of the Revenue Department at the state of Georgia or the Internal Revenue Service. Listen, they don't like to do a lot of extra work. I mean, if you're willing to work with them, if you show them how much money you're making, if you show them how much money that you can afford to devote toward taxes, if there is a way to make it work, I have found that that's the good time to do it. It's not when you try to go hide, not pay them, the debt keeps growing and growing and growing, and now you come in and say, oh, I need some help. Well, you're not going to get a lot of friendly help. You'll get some required answers to questions, but it's best, like as Skip said, to just deal with it outright, and you don't have to talk to the IRS. If you're looking at bankruptcy, but one thing we do all the time, I don't hesitate to pick up the phone and call Internal Revenue Service or Department of Revenue in the state of Georgia or Virginia or anywhere else to say, hey, we got to work this thing out. This guy's going to go down completely and you're never going to see anything, and he's going to be living in a worse place.
So what other things cannot be discharged in bankruptcy?
Well,
go ahead, Skip.
Alimony, child support, those kind of things. Taxes, a bunch of your taxes cannot be discharged. If you have some old taxes and they've never filed tax liens against you, you might be able to discharge some of that. Of course, student loans are non-dischargeable, and I've seen people come in here with hundreds of thousands of dollars in student loans. And
this question came from someone with a law degree, so I think that's what they're asking about is student loans.
Yeah. Unfortunately, there's really nothing you can do besides pay them. And of course the problem is that you can go into a forbearance period, or maybe they're not going to. They'll treat the 5 years you're in a Chapter 13 like a forbearance period sometime, but interest is being added to the balance every day. Just remember that when you're not paying your student loans, even if they're saying, oh, we'll leave you alone, we'll give you a 6-month forbearance period here, or we won't try and collect while you're in the bankruptcy case or something like that, they are adding interest to your balance every single day. And that balance is going to be higher when you emerge from that forbearance period or from your Chapter 13 period. So, I mean, those are the things I think of in terms of what's not dischargeable. Now, in an individual case, there can also be some things that might not be dischargeable because, oh, you defrauded a bank or something like that. Like say you gave a bank a false financial statement, represented to them that you had assets you don't have. If you've been involved in that kind of conduct, they can file a lawsuit within your bankruptcy case, which is called an adversary proceeding, to try and have either you get denied a discharge completely, or to at least have that creditor's debt declared non-dischargeable, which is the better situation for that creditor because all the other debts get discharged, and then they can pursue you, and you don't have anything else to answer to. So,
a simplistic way of looking at it is, if you think that you have broken the law or committed a crime by dealing with other people, you pretty well have a situation that's more than likely going to come to a dischargeability issue. Some of those things can be worked out without turning it over to the Department of Justice to have them bring an action against you themselves. So, but you can't forget it. If you think that you have done something like that, whether you know it, that it's a crime or not, you need to tell your lawyer about it, because he doesn't want to go into court and be surprised.
Yeah, don't surprise your lawyer.
We really need to know everything about you and your economic life, or we can't really cover all the holes. We have to deal with it. We have to deal with it, or else you lose. We get upset, you lose.
So the next question I got is, have you already seen an increase in bankruptcy filings? Because we've heard that Neiman Marcus is filing bankruptcy this week. Are you expecting a huge increase in filings in the next few months?
Well,
not seen an increase. No. Go ahead, Jim.
If you ride down the street and look at all the small businesses, okay, and they're closed right now. A few are open, okay, but most of them are closed. Those people have had to sit there. And number one, it would have been dangerous to have a bunch of people come in there in the first place. But secondarily, they have not been able to generate revenue. So, and it's been several months now. And that's a lot. Most small businesses are tight, between revenue and expenses. So what happens is now they have to figure out, okay, how can I get my doors open? I've been closed for 3 months, so I've got to restock my shelves. I'm a grocery store. The food's no good. They've got to have money to do that. And either they've got their own wealth that they can put into the business, or they're going to have to see if the government will help them out for a while with a loan so they can open the business. Until that happens, really and truly, nothing's going to happen to save that business in bankruptcy court. New money will save it. Loans may save it, but you got to deal with the lenders and the government for that. But it may very well lead to a bankruptcy where you don't have your business anymore. You can't pay your bills, and you just got to start over, as you say, get your fresh start and move on. And I don't know how. I don't have a handle on that right now either. I know that. I mean, my personal belief is that if you work in a manufacturing facility, a large manufacturing facility, you got probably a pretty good shot of that manufacturing facility continue, because the whole nation needs those manufacturing facilities to keep pumping out product. It's the small mom and pop operations that'll really take a personal hard hit, because if they can't buy a new product to start their business again now, they may not be able to open those doors. And I venture to say, if they've been renting, they may be behind in their rent too, and they just got to have a friendly landlord.
Skip, what do you think? Have you seen an increase in bankruptcy, or do you expect to see one?
I expect to see one. We've managed to stay open, at least half days here through the last 6-8 weeks here. And we have filed cases, and life goes on still, even though we may be under quarantine. But I expect, that once all of this gets a couple more months down the line here, it's inevitable that we're going to see more bankruptcy cases, business and personal. And I would say one thing about that too is be careful using your credit cards during this time here, because you are presumed to have been insolvent for the 90 days preceding the filing of your bankruptcy case. So if you've charged up a bunch on your credit cards during that 90 days, those creditors can complain to the court that portion of their debt should not be discharged because you were insolvent. You had no ability to pay that debt when you use those credit cards for that. So for example, say you've got a Discover card and you have a balance of $10,000 on it. Well, if $3,000 of that was charged up in the 90 days preceding the filing of your bankruptcy, they can get that $3,000 accepted from your discharge. So, and I get it. People are struggling right now. People are latching onto whatever they can latch onto so they can make sure they can feed their family and such like that. And I certainly get that. But just remember that if we're going to file a bankruptcy case for you at some point, we may want to wait a while to let a lot of that 90-day period go by, cut up those credit cards when we're ready to file, and then let 90 days go by or close to 90 days go by so that, whatever you charged up in that 90 days preceding the filing of bankruptcy, we won't have these dischargeability issues.
But if you'd have been able to understand what you needed to do beforehand, you wouldn't have charged that $3,000 anyway, and then you wouldn't have to risk that. You just need to be aware of the fact that there are things that you're not even cognizant of that can happen, if you're just doing them and you don't know whether you can or cannot, or whether this would detrimentally affect filing a bankruptcy. Bankruptcy is really there to help companies and individuals get the debt straightened out one way or the other. And I mean, we're very fortunate to have it. We don't just pack you up and send you to Australia and let you off the boat and say, see you later. There's a way, there's hope. Okay. And that hope is in the bankruptcy court. It really is. They do a magnificent job over there of steering that through the system.
They do. The bankruptcy court is so well run.
It's a federal system. It's a federal system. So you have the bankruptcy court, and you have the United States District Court over that, and we have the 11th Circuit Court of Appeals in our area, and you have the United States Supreme Court, and you have a multitude of other small courts that are specialty courts that are there to deal with these questions, and in a logical and humane way. So don't be afraid of the courts, and don't be afraid to ask the questions, and don't be afraid to talk to your lawyer.
Definitely. I think the message of this is talk to a bankruptcy attorney. This is not something you can go it alone. Our last question that we got is, how do you think a large influx of filings in the next few months will affect the timeline of individual bankruptcy cases? Do you think this is going to make it a lot more difficult to get through the court system? Is it going to take longer? Will it affect the people who have filed in the next few weeks and months?
Well, it's already taking longer than it had been, because of the fact that we haven't had hearings, much in the last 6 weeks or so here, and we're starting to have some telephonic hearings and all that now, and there's bound to be a backlog of cases, that are out there now, because again, we haven't had meetings of creditors, we haven't had confirmation hearings or anything like that. And yes, I know my case has got a bunch of stuff that's just waiting for a hearing before the court right now. But the fact is, once you file the case, that act of filing the case, that's what puts the stay in effect, so that your creditors can't bother you. And if it takes a couple months longer, well, it takes a couple months longer to get everything worked out. But in the end, it all will get worked out. And it's more impetus for all the lawyers to work to try and get all these individual issues in various cases worked out. And I mean, you've been in bankruptcy court, you know how it works. Most of the time we work out most things in the cases, and then the judge hears the few things that cannot be worked out. Well, of course, there's going to be a lot more pressure on us to get everything worked out now, I think, so that not as many cases have to be heard. But it'll happen. We'll get it worked out.
Well, the only people you're going to hear from, if you just go ahead, if you're ready and you file the bankruptcy, okay, and you are working on your schedules and you get your schedules filed, all while this is going on or anything else, the creditors will, if they're going to call anybody, they'll call your lawyer. They won't call you. Your phone won't ring anymore. You won't have stacks of mail sitting out there, and you really don't even like to walk to the mailbox because you know what's in there. There may be one that that got sent out before they knew about the bankruptcy. But the first thing that happens is the court sends a notice out to all of the creditors you listed. If you don't list a creditor, they won't know about it. But if he's listed, he'll know about it. And in addition to that, if anything has been happening, I can tell you, I will generally talk to the creditor myself and say, we're filing this next week, or we're filing this now, so that they'll just leave you alone while you get this thing done. So you will have your day in court, and you will not have to personally defend yourself every day while all this is going on. Like Skip says, once the thing is filed, everything calms down out there. Now the creditor's got to decide how much time and effort the creditor wants to put into this, or whether he wants to just let the court do its thing.
One thing I have noticed is how incredibly collegial the bankruptcy bar is. I mean, everybody just seems to get along so well and work together and communicate well. And it turns what I think seems like a very scary process to a lot of people into something that is not quite as scary as they had expected.
Oh, that's why I became a bankruptcy lawyer in large measure. I mean, I started off in insurance defense, defending traffic accident, personal injury cases. And there was so much gamesmanship and stuff going on in that area of the law. And then I by accident happened to come into bankruptcy court and it was like, this is a much nicer. This is the kind of thing I thought I was going to be doing when I was in law school.
Civilized, so
Yeah,
civilized.
yeah, yeah. You argued the facts and the law to the judge, and he made a decision, and it was a whole lot nicer.
It
But I'll tell
really
you,
is.
I'll tell you, one thing that you mentioned earlier about, well, when should people know? I, you are where you are. You may have debt problems. They may not seem solvable, and without a bankruptcy case, they may not be solvable. But you have to first become comfortable with the concept of, look, I know where I am. I know I've got these debts here. I've got to do something with them. Go see a bankruptcy attorney. Go talk to them. Find out what your options are. There may be options you have no idea about. That are real solutions for your situation, but you're not going to know about them unless you go see a lawyer that is experienced in these areas, who can walk through your factual situation and give you guidance as to, all right, I see what your problem is. We can try and cure it this way or that way. I mean, but the first step is coming to grips with the fact that you have a problem, and you need to go take care of it. And I tell you, that's one of the most fulfilling things about a bankruptcy practice to me too, is that people come in here, they're at the end of their rope. They think the horrible things are happening to them. I tell you, financial problems will put far more pressure on a marriage than infidelity ever will. I mean, people come in here all the time, and you can tell one member of the couple blames the other one for the situation they're in, and vice versa. And they're on the road to divorce too, and say, man, hold on, let's get a grip on all of this stuff again, and maybe at the end of this thing, you guys can find the magic again and go forward in your life. But again, the first step in all of this is recognizing that there's a problem here and deciding that you're ready to do something about it.
In many cases, in a married couple situation too, the decisions have to be made. Maybe the husband and the wife are subject to action by the creditors. Maybe it's just the wife. Maybe it's just the husband. That's something that has to be analyzed too. Obviously, you don't want to file somebody into bankruptcy if you don't feel like you have to do it, and we're real careful about that. But the main thing is to stop being afraid to get up in the morning and answer the telephone, because you can't get anything done during the day. You can't make money because your phone keeps ringing and people are still trying to say, I need my money, and I need it this afternoon. And that's when you know. You don't have to say, hey, when do I need to call my lawyer? You'll know, because you can't get anything done. They're bugging you to death. And listen, you're talking to lawyers here who think that in many cases, creditors are the best things in the world. They actually lend you money. They actually want you to succeed. They actually want to sell you products. They want to do all kinds of things to help you make it, because you're one more target that they can make money off of and grow. So it's personal, but it's business, and don't be afraid to deal with your business.
So any last words of advice for individuals or businesses who might be thinking about filing bankruptcy?
Well, in part what I just said a couple of minutes ago about, and this is what I say to everybody: you are where you are. Let's find the best way forward. And you're not going to find out what that way is unless you come in and talk to somebody about what the situation is, and then find that best way forward for you so you can live.
And you need to struggle hard to get out of that mess and start making money, so that you can go see Rachel, so that she can tell you what you need to do with all that money when you die.
Yeah, build that estate so you can then go to
That's right.
next estate planning. Yeah.
That's right.
If you don't have a nickel to your name, and you never will, you don't have to worry about your estate. Pretty foregone conclusion. Thank you, Rachel. That was very enjoyable. I hope your followers out there got a little bit of information they could take home.
Yes, they did. We're getting good reactions, and you just got a compliment from John Davis, both of you. And
Buy
how
flowers.
buy flowers. How can people reach you, Skip?
Well, again, I'm downtown at 115 West Oglethorpe, and our office phone number here is, of course, 912-234-6872. And call in, talk to Laura, set up a time to come on in and see us.
We love Laura.
We love Laura. Yeah. And come on in. We'll sit down. We'll have an honest talk about your situation and see. There are plenty of people I recommend. No, you don't need a bankruptcy. A bankruptcy won't help you. And if that's the situation, we'll tell you that. We're not going to try and force you into a case, but you need to sit down with a lawyer and give a good, honest discussion of your situation, so we can find out what is the best way to make it so where you can continue to thrive in life.
Well, the thing is too, if either one of us, I mean, I know the way I do it. If I get a call and it's something that's not something that I'm doing on a regular basis, or don't have time to do that, I'm working on other things at the time. First thing I'm going to do is say, you need to go see so and so, and I'm going to give them a bankruptcy name so that they can go. I would say we have a choice of a number of real good bankruptcy lawyers in Savannah, and Savannah is probably one of the most tranquil cities in the country to either practice law or to do business, if you want to know the truth about it. It's a great place to be. I think you can tell that just by riding the streets right now and seeing how everybody, for the most part, has followed the rules, stayed home. If they go to work, they go straight to work. And so they're doing their part. And that's what we're trying to do too. So anyway, I wish everybody good luck, and I hope that they do come out of this thing. I do believe it will not be long before business recovers, because this country knows how to make business happen.
Jim, how can people get a hold of you if they have a question for you?
Say again?
How can people get a hold of you if they have a question for you?
Well, McCallar Law Firm, and I'll give you the number, which always works. One or two or three people, one of the three will answer the phone. It's 234-1215.
Great.
And we're right across from the Corps of Engineers in downtown Savannah. So
we're in the same building. He's upstairs, I'm downstairs.
One-stop shop.
But I would say, call first. Don't just wander in.
Definitely.
Call first.
Well, thank you guys, both of you, for the advice. You turned a subject that is seems really scary into something that seems like you can make a way forward and make it manageable. So thank you both. Really appreciate your time.
Good to see you, Rachel.
Bye.